Hello there. Now imagine being at home watching an exciting drama on your favourite streaming service when an unexpected knock at the door brings that drama right onto your doorstep in the form of a TV licensing official and a couple of police officers and a search warrant. Would you know what to do? Now I would normally suggest you watch some videos on YouTube about it. However, so many householders and commentators get it very wrong, and I'd suggest that's because they think all warrants have the same requirements for their execution, but they don't. You'll find all sorts of claims, from the police are only there to prevent a breach of the peace, to the original paper warrant has to be physically handed to you before anyone can enter. And there are lots of claims in between. Some are correct, some aren't. So, in this video, I'm stepping back from what's available online and I'm going to the law itself and setting out 12 things you need to know about a TV licensing search warrant before they come knocking at your door. Welcome to Grey Matters. Hello there, and welcome to Grey Matters, the channel that promotes the fact that the older generation still matters and has relevance, and which looks at issues that matter to the older generation. Now, in nearly all of the interactions I've seen online, it appears that the householders and commentators are basing their knowledge on what they know about police search warrants, which are arguably the most common you'll come across. But what they know about police search warrants is a far cry from the truth when it comes to TV licensing. Why? Well, because all warrants don't have the same requirements for their execution. And that's because Parliament has created warrant powers in numerous different acts for very different purposes. So, for example, bailiffs, the police and TV licensing are all operating under completely different statutory rules. Now, before we get into the meat of this and these 12 facts, I have 3 important qualifications at the outset. First of all, the information in this edition of Grey Matters relates to England and Wales. Scotland has different procedures. And secondly, I'm not a lawyer, not even close, but I can read. And the facts I'll be giving you come from the primary legislation that covers TV licensing warrants, which is section 366 of the Communications Act 2003. Nevertheless, nothing I say in this video should be construed as legal advice. For that, you'd be best contacting somebody like the Black Belt Barrister. Sorry Dan, I hope you don't get flooded now. And thirdly, I'm not going to be quoting the legislation word for word throughout this video because I don't want you falling asleep. However, I will if I think it's needed. And apart from that, I'll explain things my way so you hopefully will understand it better. And also, when I refer to the Act, as I will be often, you can take it as read that I mean section 366 and all its subsections. Now, if you want to challenge me on the details, please go ahead. But do bear in mind that a TV licensing search warrant is not the same as a police search warrant, and that really matters because police warrants are granted under PACE Code B, and they have their own rules and detailed provisions on governing police searches. So we shouldn't simply take a rule that applies to the police and assume it automatically applies to a TV licensing warrant. And that's where a lot of the misinformation online comes from. Right, let's get started. Fact 1. Before a search warrant can be granted, a magistrate has to be satisfied that there are reasonable grounds. Now, TV licensing has to give information on oath that there are reasonable grounds for believing that an offence has been or is being committed. And because the warrant would allow TV licensing to search the premises or a vehicle for evidence, the magistrate must also be satisfied that evidence is likely to be there. And that means that TV licensing shouldn't have a warrant issued simply because an address doesn't have a current TV licence. There has to be more, and that is a statutory threshold that TV licensing must meet. And the magistrate must also be satisfied that one or more other conditions apply. Now, these conditions include circumstances where maybe there's nobody at the premises who can grant an entry, or grant access to the evidence itself. There may be occasions where the enforcement officers know that they're not going to be allowed in without a search warrant, or where they believe a delay could frustrate or seriously prejudice the search. Now, if TV licensing can't convince the magistrate that these thresholds and requirements have been met, then a warrant is unlikely to be issued. Right, that's that one. Fact 2. A warrant only lasts for 1 month after it's granted. The legislation does contain safeguards for you, and one is that the Act says a person, TV licensing, must not enter more than 1 month after the day on which the licence was granted. So if you are checking a warrant, the date of grant is important. That 1 month is a statutory limit. Fact 3. The warrant is only for authorised persons. Now, this is, I think, one of the most interesting points, because the Act says that the warrant authorises any one or more persons authorised for the purpose by the BBC or by Ofcom. But it doesn't necessarily say the warrant has to contain the personal name of one particular employee. So the simplistic rule you'll hear bandied about that if the exact name isn't printed on the warrant, it's invalid, isn't accurate. The important question is whether the person actually exercising the warrant is one of the people authorised to do so. But what if the person is named but not present? Well, again, because of this particular Act, the absence of that person doesn't necessarily mean the warrant is invalid. The question as before is whether the person who's actually there has the necessary authority to exercise it. But how can you tell? How can you, as a householder, verify that the person with the warrant is actually authorised? Unbelievably, the Act doesn't give the householder any statutory mechanism for independently verifying that on the doorstep. You should certainly check to see if the warrant contains a name, and then ask to see some ID to establish they are the person named. And if you can also ask them to explain their authority to execute the warrant. But currently there's no mechanism, for example, to phone this number to confirm the person's authorised. I would also avoid physically obstructing entry while trying to resolve this question, because the Act makes obstruction an offence. And bear in mind that although asking questions to clarify your position isn't the same as physically physically obstructing the execution of the warrant, who knows what the people present could interpret, how they could interpret it. So just be careful. Now then, fact 4. The legislation expressly expects police officers will be present. Now there's another common claim that needs correcting, which is that the police are nothing more than passive observers whose only possible function is to prevent a breach of the peace. Now, I believed that, and I'm pretty certain that applies to bailiffs' warrants. But in this case, the Act actually says that the authorised person can enter the premises either alone or in the company of one or more constables. So the legislation expressly envisages that the police officers are going to be present, and it supports the proposition that the police have an active role. So if they aren't there merely to keep the peace, what are they there for? Now, I'd suggest they're there to help maintain control of the situation and safety. I would think they're there to deal with any case of obstruction, deal with an arrest if there's a police power of arrest arising for some reason, and no doubt they'll be there to protect the TV licensing officers, and of course to exercise powers of entry where no warrant is needed, such as to prevent serious damage to property or to save a life. And although they can take this active role, they don't inherit every power in the warrant. And that distinction becomes particularly important when we ask who can use force to enter. And we'll look at that now in Fact 5. Because Fact 5 says the police can have an active role, but the source of their power matters. TV licensing owns published information says that it executes search warrants in the presence of police officers, and it also says the accompanying police officers may themselves force entry if they deem it's necessary. Now that's TV licensing's status policy, but how does that stand up to the wording of the legislation? Section 366 says that the authorised person may enter in the company of constables and may use reasonable force if necessary. The Act does not expressly say that the accompanying police officer has the same power under the TV licensing warrant. A TV licensing warrant isn't a PACE warrant that confers powers to the police. So if you ever find yourself in that position, facing a TV licence warrant and a constable physically assisting in enforcing entry, I'd suggest the important legal question for you is, what is the source of the authority that permits the constable to do that? Where does he get his power from? We shouldn't jump from the Act permits reasonable force to every police officer accompanying the warrant has exactly the same power, because they don't. Now then, fact 6. Reasonable force doesn't have to be written into the warrant. Now, there are commentators who claim that without this endorsement written into the warrant, TV licensing has no power to force an entry. Now, this is a myth that's worth correcting, because the power to use force doesn't come from the warrant, it comes from the Act under which it was granted. Section 366, subsection 6 in this case, which expressly says that a person authorised to execute the warrant may, if necessary, use such force as may be reasonable in exercising that power. So the legislation itself supplies the reasonable force power to the authorised person. It doesn't necessarily have to contain the words reasonable force may be used. That's the warrant, doesn't need to have those words. And if it does, all well and good, but if it doesn't make the warrant invalid. Now, fact 7. A TV licensing warrant doesn't allow the officers present to search for anything they want. The warrant has a defined statutory purpose, which is to enter, search for, examine and test television receivers found there. It isn't a general purpose warrant to search for drugs and weapons, stolen property or evidence of something completely unrelated. But if the TV licensing officers discover something suggesting an unrelated offence that's nothing to do with them, it raises a separate question about whatever police powers may apply, but that's got nothing to do with TV licensing. Now, fact 8. You have a duty to provide reasonable assistance. Now, this is important because another misconception is that the warrant doesn't impose any obligations on the occupier. But the Act says a person on the premises has a duty to give the person carrying out the examination or test such assistance as may be reasonably required. And it makes it an offence to intentionally obstruct them or without reasonable excuse to fail to provide that assistance. Be careful. Now, fact 9. Now, this is an interesting one because fact 9 is that a wet signature isn't specified by the Act. You've probably seen these claims that the magistrate must personally sign the warrant in ink and that the warrant without a wet signature is automatically invalid. Now, I'll be very cautious about making that claim because the Act doesn't specify it. That doesn't mean warrants never have formal authentication, but it means people shouldn't invent a specific wet signature requirement for a TV licence warrant unless they can identify the legislation or court rules that actually impose it, and there are none. In fact, the Magistrates' Court Amendment Rules of 2019 removed the general requirement for signatures on certain magistrate court warrants, and the Ministry of Justice has specifically said that warrants no longer need to be signed unless the statute requires a signature. And Section 366 of the Communications Act has no such requirement. Now then, fact 10. Another one that will cause consternation, I'm sure. The original paper warrant doesn't have to be handed to you before entry. This is another area where different types of warrant can easily become confused. For police warrants under PACE, there are specific requirements concerning production and provision of copies of warrants. But Section 366 is different, and it contains an interesting provision. One of the circumstances, if you remember, that I mentioned before about applying for a warrant, one of those circumstances is that a TV licence warrant will be needed if entry would not be granted unless a warrant is produced. But that's not the same as producing an original paper warrant and handing it to the occupier. So if someone turns up with a warrant, it's perfectly sensible to ask to see it, but I'd suggest it would be unwise to assume that no original paper document in my hand means that no legal warrant exists. Right, fact 11. The warrant must relate to a specified premises or vehicle. Now, TV licensing warrant must be tied to a premises or to a vehicle, and it'll be specified in the information that TV licensing put forward. So the identity of the property matters. If there's a genuine question about whether the address or premises actually correspond to the property, that's something worth raising. But again, be careful about saying that any spelling mistake or minor clerical error automatically makes the warrant void. The legal question is whether the premises are sufficiently identified and whether the warrant actually covers them. And finally, fact 12. An irregularity doesn't automatically mean that the warrant's invalid. You will often see advice on the internet saying, missing signature invalid, wrong wording invalid, wrong name invalid, no original paper, no entry. The law is rarely that simple. I think the important thing is that you need to know what the warrant authorises, know who is authorised, and you need to check the date and the premises covered, and then also understand the purpose of the warrant. If you believe something is wrong, I'd suggest maybe if you can't resolve it at the time, resolve the legality afterwards through the appropriate legal process. So there you go, it's 12 facts based on the legislation under which TV licensing search warrants are issued. TV licensing itself says that its visiting officers have no legal power to enter your home without a magistrate search warrant. Without the warrant, you can refuse entry. But remember, a warrant changes that position because it's judicially authorised and is a statutory power. Now, my non-legal, non-expert advice is, as I've said, to check what the warrant authorises, who is authorised, and that it's still within its 1 month validity, and that it covers the correct premises. And if you ever have any doubts about this, I would urge you to consult a solicitor to keep you on the right side of the law. Just remember not to physically prevent the warrant's execution while you seek advice, because that will very probably be seen as obstruction, and that could open up a whole new world of pain for you. So have you ever had a TV licensing turn up with a warrant? If you did, what happened? Did they follow the rules? As always, let me know your thoughts in the comments. And if you like the video, please give it a share and hype it, and I'll give it a big fat thumbs up, and of course subscribe. As always, a big shout out to our viewers who have taken up channel membership, and especially big thanks to everyone watching for your continued support. I'm looking forward to reading the comments on this one. So until the next time here on Grey Matters, I'm going to make sure my Ring doorbell's working. Thanks for joining us, and it's bye for now.